Yeah, I just wondered if you knew anything about that.
I have no comment.
Okay.
Sorry. So there's a distinction I want to make clear for everyone. There's that private administrative process, which a lot of people in the Patriot movement does. Is, there's a lot of accepted for value. There's a lot of different things, presentment. There's a lot of different processes in the private side that I'm not familiar with. I studied some of that, but I've yet to see true results reliably. The whole idea of the judge and civil procedures is like, oh my God, I'd rather, go to the dentist. But fundamentally, that's the only thing that the banks will respect. And we're playing with big stakes here. You can't afford to muck around. Time is not on your side. So do you want to do this supposed patriot thing and maybe it works? And okay, the judicial process, you're relying on the judge to be fair and impartial. He may not be. You're relying on you being able to argue and articulate your case properly. You may not be able to. Fact is, if you don't, you're going to lose your house. If you do, really, you're backed into a corner. Fighting is the only option. And I'm hedging my bet that the legal judicial process is really the only way, as far as I can tell. I mean, if we can find a reliable, dependable, non-judicial process remedy, a private remedy, I'm all for it. It's just, it's very hard to find one that actually works. I've not seen one.
Is it possible when you went to court that you had a jury, or would you say no?
So the question is, if I went to court, could I have a jury? So remember what I said, it is the bank's job to get your case dismissed. You have no case. There is no jury. Okay, that's why they do not want you to go into discovery. Discovery is where all that fun happens. Okay, all right. So if your case gets dismissed in a dismissal hearing, there is no.
I'm an expert witness, and if you ever saw a movie, it's a great movie that gives you an idea of how not only the judicial system works, but what an expert witness does. It's I think it's called Civil Action with John Travolta, all-star cast, and in the movie you see the expert witness that was hired and for millions of dollars, tearing up all the soil, trying to figure out how the toxicity in the water, or what the toxicity in the water really was. And it's so apropos in this example that we're talking about. I'm not sure if we're talking about an EPA claim or we're talking about an FDIC claim with the toxicity and the label of toxic acid. And something else you might want to note, if everyone's familiar with the trouble asset relief program, I'm sure George has spent some time at least introducing it. You begin to see a lot of interesting things in that analysis. Tom, going back to, I assume everybody in the room, with the exception of a lender or two, received a loan and they're struggling with it. And they continue to try to wait on a lender to make good on promises. And in fact, the promises never come to fruition. And the only real added insult is when they ask you to make 4 or 5 payments under a trial, and then you find out that they file foreclosure on you. But the Troubled Asset Relief Program is a taxpayer bailout of the banks and bank malfeasance. And what's interesting is that when this whole thing triggered right around the time Lehman Brothers was thought to have sunk, you have what normally would have been a securities issue. You have a 1933 stock market collapse. You have a certain sector that's stock prices have plummeted to zero. And you would expect the SEC to come in and the government to, try to identify who's the culprit in criminal charges, but that wasn't the case. When the Lehman Brothers thing hit, the new president, when he came into office, he immediately removed Bernanke and got there and cahoots. They immediately removed these issues, these stock trading issues. They removed it from SEC enforcement. All these trusts where the loans are sold into. It's not important to understand, the means and methods by which they obtain their objective, but they do it in the trust. And it's interesting that the first thing Obama does in his staff is they remove these from the SEC. They delisted them and removed them from SEC enforcement. Strange. I thought that would be one of the key ingredients of a good defense, or for foreclosure, or to launch a offense. Definitely citing SEC blue sky violations and insider trading and so on. So they removed it from the SEC. They delisted these companies. And then the next thing I thought was at least we can show that they breached the accounting rules. You know, it's a horrible comparison I'm going to make here, but if you had a choice of robbing a bank at gunpoint, God only knows how far you can get, but if you had a choice of doing that, or falsifying a tax reported, if you were a corporate officer and you were to, if you were asked to forge or to sign something that wasn't true, the bank robbery is going to get you 5 years. But the document that you forged could get you 20 years. That was the Enron law. So they removed them from the SEC, and then and that Enron law is what I'm referring to is. I'll tell you when to jot things down if you want. From an accounting standpoint, the only thing I think is important to know is that they violated FAS, F as in Frank, A as in Apple, S as in Sam 140, and subsequent codified FAS 140, FAS 140. And I'll get back to that in a minute and tell you what that means and how that may help you. It's not in a defense, at least understand how your rights have been violated. They removed it from the SEC, and then they went after the accounting rules. Geithner, Obama, and Bernanke. And they started asking the accounting rules, the Federal Accounting Standard Board, FASB. They started saying, you got to change the rules. And I never heard of such a thing. So, and I said, well, we throw Sarbanes and Oxley. Sarbanes and Oxley were two senators that around the time of Enron passed legislation that said in order to do any kind of securitization or offer stock, the investors and all the other parties are entitled to complete transparency. Transparency means you can see the inner workings and understand everything that's going on. So I guess, getting into this 2 years ago, I said, well, Sarbanes is what we're going to have to rely on. And the Supreme Court, I understand what they have to review it. I understand the Supreme Court repealed Sarbanes-Oxley. So, 3 strikes, but I think I was on the right track. I early on identified where the problems were, and that's what the government is trying to do to attack those, get rid of those things, the obstacles, before they attack the problem. But anyway, I guess I would start with just my interpretation of what's happening here. You got a bunch of parties that are all in cahoots, okay? You don't use the word conspire, you say cahoots. And we can pick anybody you want. We can do First Franklin, IndyMac beat Bank of America. IndyMac is a lender, and IndyMac originates loans as a lender, and IndyMac needs money to fund those loans. And IndyMac relied on IndyMac Federal Savings Bank to fund those loans. So IndyMac, the lender, has the wherewithal and the capacity to go out and market good quality loans, ensure that the loans coming in are good loans. And then IndyMac Savings Bank, Federal Savings Bank, was the depository, the bank that was funding the loans. The lender will put together as much as $300 million. You're one loan of a pool. You get $300 million in some instances. And at that point, IndyMac Federal Bank and the Federal Savings Bank regulators will say that's enough. Get rid of them. They don't want them on the line very long. A lot of liability there. So the IndyMac ensemble, which includes a servicer too, IndyMac Servicing, they sell the loan. They sell the loan for cash. That's what you got to understand. We got the first leg of this trip. It's a 3-leg trip. It's loans are sold for cash. And if we know your loan is sold for cash, then you got what you call a bona fide sale. It's over. It's done. Transferred. IndyMac has no right. Washington Mutual has no right. First Franklin accredited Wells. If they're going to participate in the securitization, they're going to first sell the loan. If they sell the loan, it doesn't matter who they sold it to. This party's over. They have no right or claims to that asset again. And who they sell it to is a less than arm's length secondary stock these are called private placements, by the way. They're under the 1933 Act, the Securities and Exchange Commission for private placements. It's interesting, private placements are designed for all of us. If we have a business idea, we can go out and raise $1 to $5 million. We can sell stock to act like a big company, and it's usually called a pre-IPO. But it allows small businessmen to raise money. That's what it's intended for since 1933. It's called private placement. And it's interesting that Bank of America was using these private placements for as much as $80 million. And what I can see from that is that, sure, it keeps the stock under the radar. You don't have the same SEC enforcement as you had with an IPO. But nonetheless, the lender, IndyMac's going to sell it to its own investment arm, and that would probably be Lehman Brothers or some affiliation of an investment banker. We know that the left hand is selling to the right hand, and Wall Street says that's okay. That's okay. I mean, it's an accounting scheme. There's no value to it, but it under the rules says they can do that. So if they're going to sell a loan, even to a related entity, we call it a combination or a holding company, it must meet the criteria of a qualified sale. And that criteria, any attorneys in the room, don't cringe. I'm not an attorney. I'm a witness, but I just state the facts as I see them. The key ingredients of the legal opponents, legal arguments for a lawful sale would be lawful intent and due consideration. So if IndyMac gets that loan itself for all cash, was it really cash? That's your due consideration. Was it cash? And if you record that assignment, we know they did, which questions is it lawful? Is it a lawful transfer? Is it a lawful intent? So you can attack that. I don't. Can you still hear me?
Yeah. Yes, Mayor.
Okay. I don't know if you want to attack it anyway. There's a reason for it, but I'm moving this thing along. You sell loan for cash, and then what happens is the loans go north and the cash comes south. Then what happens is the cash with the lender now goes north, and what comes south are securities. And the security are what we call book value. It's an exchange of a loan, a mortgage. Your mortgage, I hate to use the word tendered, but it's been tenderized into a stock. And in order to take a mortgage and turn it into a stock, in order to take a mortgage and turn it into a stock, I don't know why you need to do that in a private placement. A private placement, we said, is where you raise $3 to $5 million to a family and friend. If you wanted the stock to trade and have vibrancy, if you wanted people to go in and out of the stock, well, then you'd have to be able to register these loans with a national system, a mortgage electronic registration system, something like MERS, and that's what MERS does. They create a stock exchange. They create a trading exchange. And it comes up out of water. I mean, I said, do not attack MERS. Do not attack MERS. MERS is a platform. You don't attack platforms. Trains go off the track, and there's a collision and damages. You don't believe the tracks. So MERS handles this transfer of real property. It transfers the beneficial interest. The beneficial interest is what we're talking about. It transfers it into a financial instrument, which is a stock. But the way it does do this is that we have the loans go from lender to Wall Street for cash, and then the cash comes down, and the cash goes back up, and stocks come down, and then the stocks go out to market into a trust. The stocks are sold to investors that are inside the trust. And the investors now are going to buy these certificates from broker dealers, and they're going to deposit